Hi, Sarah. Welcome.
Hi. Well, I don't know why my video is not. Oh, there it goes.
There it
Okay.
goes. Hi.
Hi.
You can go on mute and turn your camera off and for about 10 more minutes. So as
Okay.
we wait for people to join us.
Perfect.
Hi, Shelley.
Hi.
Hey, let's check out your camera real quick just to make sure everything's working.
Um. Hang on here a minute. Where? Oh, there it is. Okay.
Okay, Shelley, you're going to want to turn your camera or your phone sideways. Yeah, because most of our evidence is going to be presented that way.
Okay.
You can also turn your we have another about 10 minutes before we'll get started.
Okay.
But thanks for joining us.
Okay. Thank you.
Hi, Christiana.
Hello.
Hey, let's check out your camera to make sure everything's working.
Yeah, 1 second. Okay, there we go.
Okay, you might want to turn toward the window or where it's not behind you because it obscures your face because your camera is adjusting for the light.
Okay, give me 1 second.
Okay.
Okay.
Oh yeah, that's much better. Okay, you can turn your camera off for now, and your mic off, and then maybe in about 5 to 8 minutes, just turn it back on.
Okay.
Thank you.
Thank you.
Hey, Caleb, let's check your mic real quick.
Okay, can you hear me?
I sure can. That's great. Thanks so much. Thanks for being here. Hey, Terry, let's check out your video and your mic.
Okay, hello.
Okay, I can't see any video.
Okay, hold on just a minute. Now can you?
No,
Nope.
still black.
Doggone it. Hold on. Sometimes the screen gets. Now can you?
No.
No?
Mm,
Now? No?
no, still can't see anything. Here, oh, you know what? Let me see if I can send you a mess. Okay, I sent you a message that's
Okay, there I
yes, there we are. Yep,
am.
that
Hey.
works.
Okay, super.
Hi, Kathy. Thanks for being here. You want to turn on your mic and camera and let's make sure everything's working.
Hello.
Oh, hi, Kathy. Great. Thanks for
Hi.
being here.
No problem. Do you want me to go back on mute now?
You can, yeah. Hi, Brandon. Let's check your mic and your video.
How you doing?
Okay, I hear you. Ah, excellent. Great. Thank you so much.
hmm
Thanks for being here.
We still have the 5 minutes before we start.
Yes. Mhm.
Okay, gotcha. I'll be right back.
Okay. Well, Wes, one of you made it.
Okay, we're all set.
Okay, let's check your video real quick.
Okay. There we go.
Oh, there it is. Great. Thanks, Wes.
Sure.
Ariel, let's check your mic and your video, please. Oh, okay. Let's go. Hey, Ariel. I see ya. Let's see if we can hear you.
Yes.
Okay, good.
Do I need to mute again?
Yeah, go ahead and mute until later. Hey, Glenn, let's try your mic and video.
Hey, Heather, can you hear me?
I can hear you, just can't see you.
Why is it turning on?
It might be coming up slowly. Oh, there you go. Awesome. Great. Thanks for being here, Glenn.
Cool. Thanks.
Okay, Kelly, Ariel, if y'all could get back in. Oh, looks like we lost some people. All right, y'all, apologize for my delay. I've got a name here I don't recognize, so I'm just checking real quick. Hey, James.
Hey, how you doing?
Good. How are you?
I'm doing all right.
Okay, I got you. It looks like we got everybody, and we're going to go ahead and get started. So you can just mute your mics for now, and I will share my screen with you. All right, everybody see that? All right, we're just going to go through a brief orientation. Our expectations are that you attend the full 2-hour focus group. Your camera must remain on at all times, and your face must be visible on camera for the entire session. So Kelly, you'll need to turn your camera on, please. Focus exclusively on the session and no participating in any other activity. Please answer the questions with honest feedback, because that's what we're here for, is your opinion. Let's see. To avoid talking over each other, raise your hand and wait to be called on. Sometimes the software will recognize that you've raised your hand. Please ask questions. I may or may not be able to answer your question. Sorry, I forgot to do these. Oh, wait, where are we? Okay. Okay, here we are. If you're joining from a phone or a tablet, turn it to landscape. Everybody's good. Let's see. You can zoom in on pictures to see more detail, but you must also zoom out because your screen will not reset. Earbuds and headphones with mics are helpful for hearing and capturing your voice. And keep your device stable. Moving your device or moving to different places in your house is very distracting. If you get up and move and wander around, I'll just have to boot you out. It is so distracting for people, and we just learned that after so many tries. So, find a good seat and try to get comfy. Everything we discuss here is confidential. This is not, because it is based on a real trial, real case, but this is not like a trial. You'll be shown bits of information and it's limited, and then we'll discuss them. Real people have biases, so we want you to share your honest opinions, but also be respectful by listening, even if you disagree. And please share the reasons behind your thoughts and your opinions, because there are no wrong answers. You're free to discuss or reference other comments, but it seems I'm reading my notes, but not reading what's on the screen. I apologize. Please ask questions. If relevant, our legal team will provide answers. Given our time constraints, our primary task is to make a decision based on the available evidence and the facts presented, and payment will be made at the end of the focus group. So your purpose is to give your honest opinions on information from a civil lawsuit. These comments and questions help real people involved in the case resolve issues and clear up confusion. I'm an outside party hired by the attorneys to present this case. I only have the information that I've been provided, and I have no vested interest in the case. I'm not for or against either way. So this isn't like a TV show where everything gets solved in an hour with commercial breaks. So we got to get through it. Only consider the evidence you are provided. There's no real conspiracies or any of that. So you just don't even go there. Don't assume the insurance is fraudulent or anything like that. We're just sticking with what we know. It's not a criminal case. You must decide based on what is presented, but if there's something you want to know, please ask. I know I've said that over and over again, but it's really important that we know what you're thinking. I may have to interrupt if we get off topic or test. I'm not trying to be rude, but it's just keep us within our time frame and focused on the goal of the focus group. And ultimately, we may have to come up with a verdict using only the facts that were presented. Okay, so with that being done, we're already 3 minutes late. So we're going to start with case review A. Okay, so the first thing we're going to do is I'm going to go through a case narrative, and then you'll review evidence and an eyewitness statement, and then we're going to review what's called the jury charge for the case, which is what you're going to have to do for the case. Okay, so here we are on September the 12th. Mary, a college student, and her boyfriend Richard went to a baseball game in Atlanta, 66 miles away from her home. Richard was driving Mary's vehicle, a gray sedan indicated by the V2. You can see that there, on the way back to Rome, Georgia. This is around 10:30 at night, and Mary's vehicle was rear-ended by Peggy in a blue SUV indicated by the V1 that you can't really see there while at a stoplight. And this is the exact intersection that they were at. All right, this is the accident report, and I'm going to pull that up for you. And I'll zoom in so you can kind of take a look at some of the information here. Or this. There are no injuries in the accident and no airbags deployed. Okay, this is the damage to vehicle 2. It is the back of vehicle 2, which is Mary's vehicle. Now just hold the pictures here for just a little bit so you can kind of take it in. Last photo. Okay. Mary and Richard were planning to go straight through the intersection, but after being struck, Richard turned right and then into the gas station. You can see the V2 vehicle taking a right here onto Cobb Parkway and then pulling into the gas station. That's a Chevron. Peggy left the accident and went home. She traveled straight. She said she thought the other car was leaving. So that's her blue vehicle driving straight. Anybody need to see that anymore? Raise your hand if you do. No? Okay, good. All right, this is a rendering from Google Maps showing where the Chevron gas station was in relation to the accident. You can see it right there under the sign, here at the corner. And this is where Richard took the vehicle and turned into after the accident happened. Okay, we're going to listen to the 911 call.
911, what is the location of the emergency?
Hey, we are, hold on, I'm trying to see
there was a hit and run. We got hit and then they just left. Hold on. We're on North Marietta. And Cobb at the Chevron.
Okay. Did it happen in the parking lot, or did y'all pull into the parking lot?
No, we pulled into the parking lot.
Okay.
It happened at the light. We were stopped at the light. They hit us from behind, and
Okay.
then we just pulled into the parking lot, and then they didn't follow us. They just kept on going.
You did? Okay. I need to
Oh,
get the
okay,
vehicle
okay. I think. I think somebody got their license plate. I think they're gonna come in.
Okay. I need to get the vehicle description that left.
It was an SUV. It was pretty dark, so we couldn't really, you know what I mean? Like,
Yeah.
I couldn't really see that well.
Okay.
But I think somebody's coming
Okay.
with the.
Okay. Yeah, that's fine.
Yeah.
What direction did they go?
They went down Cobb. So like the intersection is North Marietta and Cobb, and they just went down Cobb. We're coming back from the baseball game, so I'm not too familiar with the area.
Okay. I need to get the driver's description. Well, what race and gender were they?
The driver's description.
Yeah, I know.
She was
she was a
middle-aged lady with circular glasses and curly hair.
White, black, Hispanic, or Asian?
She looked white, right?
Yeah,
she looked white. Yeah, she
Okay.
looked white.
I need to get the description of your vehicle. What color, make, and model is it?
Yeah, it's a gray Nissan Versa.
What is the location of the?
Okay, that was the end of that audio. Okay. As you heard him say, an eyewitness saw the accident and got Peggy's license plate number and gave it to the police. Peggy was found at fault for the collision and was cited with following too close and leaving the scene of an accident, hit and run. This is the eyewitness's statement. I was directly behind the SUV that caused the wreck and saw the whole thing. I had my windows down when the blue SUV hit the gray car and I could hear the impact. The blue SUV then backed up and the gray car turned into the gas station. It looked like the SUV was going to follow the gray car, but then when the light turned green, it drove straight through the intersection really fast. Instinctively, I followed the SUV. It sped up and, to me, appeared to be driving quite fast as if it was trying to get away. I followed it for about a half mile before I was able to get the license plate number. After that, I returned to the gas station and gave it to the people in the gray car. Now, Peggy does not dispute liability for causing the accident. However, she does dispute that she intentionally attempted to evade detection and responsibility for the collision. After the police completed their report at the scene of the accident, Mary and Richard drove home. All right, this is the arrest warrant here. And it shows the struck the other vehicle, failed to stop, and drove off. Okay. So the next day, Mary went to the ER with complaints of neck pain and a headache. She was examined and had a CT of her head and cervical spine. She was diagnosed with whiplash injury to her neck, given a prescription for a muscle relaxer for spasms, and told to use over-the-counter pain medication. These are her medical expenses. The medical center charged $8,829. The emergency room physicians who saw her there charged $1,280, and then the CT scan cost $495, for a total of $10,604. Okay, now we're in the arguments section of this case. In a minute, we're going to hear arguments from the defendant and the plaintiff. The arguments focus on damages to the plaintiff and will include arguments for medical expenses, pain and suffering, and punitive damages. You're to pretend that you're a juror hearing this case and that it is your job to determine the amount, if any, of monetary damages that the plaintiff is entitled to. I will first review compensation for damages and punitive damages. and then we'll hear the arguments. So as a guide, in personal injury or tort cases, a plaintiff is entitled to damages or compensation for the reasonable value of reasonably necessary medical expenses, such as hospital, doctor, and medicine bills, and for pain and suffering. Before you may award or impose punitive damages, the plaintiff must prove that the defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that that entire want of care that would raise the presumption of conscious indifference to consequences. Mere negligence, although amounting to gross negligence, will not alone authorize an award or an imposition of punitive damages. So if you are understanding, we have medical, we have pain and suffering, and then we have punitive damages. So there are three damages that we're dealing with. Okay. So now we're going to listen to the defendant attorney. So Peggy's attorney.
Ladies and gentlemen, it's my pleasure to represent Peggy in this matter and to speak with you on her behalf. Now, for starters, let me say this. Peggy does not dispute that she was involved in a minor collision with Mary's car on September the 12th, 2025. Certainly, their two cars made contact that evening in Atlanta on that busy highway. That's undisputed. The issues that are in dispute, however, are the severity of Mary's resulting injuries, if any, the amount of damages that you should award to Mary, if any, and whether punitive damages are justified in this case to punish Peggy for what happened. When you examine the evidence in this case, it appears to me that Mary certainly is entitled to some compensation, but not nearly as much as she wants you to award. And the reason is, this collision was very minor. The injuries, fortunately, were also minor, and Peggy's misconduct, or mistake, however you see it, was not malicious and just does not justify punitive damages. So let's discuss the evidence in that order. The collision. Let's begin by looking at the physical evidence, the car involved. The collision occurred when Peggy struck the rear of this vehicle, and I want you to look at the rear of this vehicle and the resulting damage. Mary was riding in the car as a passenger. Her boyfriend, Richard, as you heard on the 911 call, was driving. These pictures show the resulting damage to the vehicle, all of it. There was no damage to the frame, the tires, the mechanical workings of the car, no airbags deployed, no lights were broken, nothing was cracked, nothing fell off the car. Mary and Richard were able to drive the car afterwards without any problem. In fact, they left the scene and drove over an hour and a half back to where they live after this happened. And I think by all accounts that we can agree that this was a minor collision, a fender bender, so to speak. And frankly, many times, maybe most of the time, people walk away from these types of collisions without any injury whatsoever. And in fact, that appeared to be the case here, initially at least. The collision happened at 10:35 p.m. On the evening of September the 12th in Atlanta. According to the accident report, there were no injuries. I can show you a copy of the report here where the investigating officer completes his form and asks each of the occupants and drivers if they had any injury. As you can see, each of them reported 0 for injuries. No one sought medical care, no ambulances were called. And even when they did call 911 and the 911 operator asked if there were any injuries, they didn't report any. And you can hear Richard, Mary's boyfriend, there on the phone, and at least to me, it certainly didn't sound like he had suffered any injury. And after speaking with the police, they got in the car, drove over an hour and a half, went home, apparently probably went to bed. And sought no medical care that day. In fact, they didn't seek any medical care until the next day, September the 13th, at about 4:50 in the afternoon. That would have been a Saturday afternoon. They both decided, the boyfriend and Mary, both decided to go to the emergency room and seek medical treatment. So let's look at some of the medical records, okay? As I said, the wreck happened at about 10:30 at night on the 12th. They go to the ER on the 13th at about 4:50 in the afternoon, so that's almost 24 hours later. And Mary reports some neck pain and a headache. I can show you here from the medical records. This is her history and initial complaints, a review of the systems, her body systems. And her physical exam was basically normal, except for some neck pain and a headache. Exhibit 5 is the physical exam, the musculoskeletal exam. It shows a normal range of motion, that her neck's supple, no focal deficits, motor functions intact, sensations intact, coordination intact. They do a CT scan of her head and her neck. The results of those are normal. No acute injury is identified, no areas of concern, no additional care suggested. And importantly, I want to show you this entry from the records. At 17:02, which is it's 5:02, so not long after her admission there, the nurse performs a pain assessment. And that pain assessment records Mary as saying she has no pain. She denies any pain at 17:02, and then she's discharged from the hospital at 19:39. She's at the emergency room for less than 3 hours, maybe 2.5 hours, and she reports no pain before leaving. She's given some muscle relaxers, over-the-counter meds, and she's on her way home. In fact, they give her a release to return to work, which I can show you. And at 7:30 that night, they give her a release to return to work and say, hey, you can go to work the next day, the 14th, which happened to be a Sunday, but anyway, it gives you an indication of the minor injury she had. And she's told to follow up with her primary care provider or another emergency room if her condition worsens. And she sought no care whatsoever after that date. In fact, from that date until now, she hasn't sought any physical therapy, additional medication, scans. She hadn't gone to urgent care, primary care. Thankfully, she has not required any treatment whatsoever. So in fairness, I think we can agree this is a very minor injury. Her treatment was minimal, her recovery was swift, and that's the extent of her injuries. Now plaintiff's counsel is going to focus on these medical bills, $10,604 in charges from the emergency room visit. Now, frankly, seems like a lot to me for 2.5 hours at an emergency room for a headache and a little neck pain. And while I don't blame Mary for wanting to get checked out after this wreck, I think she probably could have gone to her primary care physician or urgent care and saved us all a lot of money. But I guess better safe than sorry. Thankfully, Mary, though, had good health insurance, and she only had to pay out of pocket $475. Her health insurance paid the rest, whatever that might have been. The $10,640 or $604 is a sticker price that no one pays, and I don't think you should award that amount. I think what you should award to Mary is $475. That's what it cost her. Now, what about her pain and suffering? I think Mary should also receive some money for her pain and suffering and the neck pain and headaches that she endured. Now, according to the ER records, she didn't endure those for very long, and there are no indications that she needed additional care. Nevertheless, I think that it would be fair to award her $2,500 for the pain and suffering that she endured. That's basically $1,000 an hour for the 2.5 hours that she was at the emergency room. That's appropriate, that's fair. Add that to the medical expenses, it's $2,975. Now let's talk about punitive damages for a minute. Plaintiff's counsel will argue that Peggy's conduct was so horrific in leaving the scene that you should award punitive damages. And as you've heard, those damages should only be awarded where the defendant's actions show willful misconduct, malice, fraud, wantonness, oppression, or the entire want of care that would raise a presumption of conscious indifference to the consequences. Mere negligence, gross negligence, is not enough. So in other words, punitive damages are reserved for terrible conduct that's truly egregious and intentionally designed to harm someone. You know, here Peggy made a mistake, a bad mistake. She was driving alone by herself in Atlanta. She bumped another car late at night, and she chose to drive away. The other car drove forward and pulled into a gas station. Things happened quickly. She made a mistake. Maybe she thought that they were just going to disregard this and go into the gas station, but she should have stopped. Frankly, Both cars should have stopped. And in hindsight, Peggy agrees it was a dumb thing to do, but it wasn't malicious. She wasn't trying to hurt anyone, and she didn't hurt anyone by driving away. She just made a bad decision. It's not like this was a terrible collision and she needed to rush out and render aid to someone on the side of the street. She just made a mistake. Dumb on her part, but punitive damages are not designed to punish people when they make mistakes unless they're designed to hurt somebody. So if you feel punitive damages are warranted in this case, I suggest $1,000 added to your verdict would send a message to Peggy, hey, you need to stop next time. So a total award, I suggest, $2,975. That's for pain and suffering and medical expenses. An additional $1,000 for punitive damages for a total award of $3,975. That's fair. That's reasonable to both parties. It compensates Mary for the losses that she suffered, and it sends a message to Peggy, do better next time. Thank you.
Okay, so that was the defense. Now we're going to listen to the plaintiff. Yes, Brandon.
Sorry, thanks. Are these like reenactors for the defense and prosecution, or the defense and plaintiff lawyers, or are these the actual gentlemen?
These are reenactors
Okay,
with the attorney arguments.
gotcha. Thank you.
Okay, let's listen to this one.
Thank you for listening to the evidence that has just been presented. As you've heard, what started out as an ordinary wreck caused by ordinary negligence turned into something much bigger. A lot of sayings can summarize what happened following the collision, but the gist of the case is this. Rather than stop and check on Mary and the driver of her car after striking Mary's car at the red light, the defendant deliberately fled the scene when the light turned green. Now, ordinarily, a jury awards damages for medical expenses and for pain and suffering, essentially reimbursement for the ordeal. However, when there are facts that are egregious or aggravated, like when someone flees the scene rather than stopping to check on the people in the other car and exchange information, a jury can award additional damages, damages that punish the defendant for their behavior. Had the defendant remained at the scene following the collision, we probably would not be here asking a jury for damages, and we definitely would not be here asking for punitive damages. Instead, Mary would be entitled to the reasonable value of her necessary medical expenses and to compensation for her pain and her suffering. A little over $10,000 for Mary's medical expenses, which includes the cost of her hospital and doctor bills, and somewhere between $5,000 and $10,000 for Mary's pain and suffering, for the ordeal, the interference that the wreck caused. As you heard, following the wreck, Mary went to the ER. Not immediately, it was the day after the wreck, when she was back in Rome, where she lives. She woke up with pain in her neck and a headache, symptoms that had developed overnight, and after the adrenaline from the previous night's events had worn off. In addition to the adrenaline that Mary was experiencing at the scene, Mary was in disbelief. She didn't understand why the driver that struck her had fled. She was worried about the damage to her car and how she was going to pay for it. And she was scared. She was an hour away from home, and it was 10:30 at night. Is she going to be allowed to drive her own car home? Will she have to stay in Marietta for the night and find a place to stay? The next day, after the adrenaline wears off, and she's had time to process the previous night's events, she realizes that she's sore, that her neck hurts, and that she has a headache. She goes to the ER and she's diagnosed with cervical strain and whiplash, injuries that a CT is not designed to diagnose. So it's no surprise that the CT imaging was negative, because CT scans are not designed to evaluate muscle sprain or strain. They're instead designed to detect bone fractures and internal bleeding. The CT scans were ordered as a precaution to rule out cervical fractures and brain bleed. A negative CT reading does not mean that there was not an injury, and don't believe the defense when they suggest otherwise. And neither does Mary being cleared to return to work on September 14th mean that she wasn't hurt. Being told that she can return to work doesn't mean that she was declared cured. In fact, as defense counsel said, she was advised that her pain may increase, and she was prescribed a muscle relaxer, and she was instructed to take anti-inflammatory medicine. She wasn't discharged home with a doctor's note that said she was fully healed and pain-free. Mary is entitled to reimbursement of her medical expenses, $10,604, not less. Just like fleeing the scene after the collision in an effort to avoid responsibility, defendant is here today continuing to attempt to avoid responsibility by asking you to reduce the medical expenses that she owes Mary. And that's not all. In addition to these medical expenses, you're allowed to award Mary compensation for the pain and suffering that she experienced because of this wreck. Mary was a passenger in her own car. She was stopped at a red light. She was doing absolutely nothing wrong when they were struck from behind without warning by a driver who then drove away without first stopping to ensure that Mary and her boyfriend were okay. So Mary was left at the scene, not knowing if the person who hit them would be identified. It was only because of a witness who happened to follow the defendant and get the defendant's license plate number was the defendant identified at all. So after waking up in pain the day after the crash, Mary spent nearly 3 hours in the emergency department. She underwent CT scans of her brain and spine, and she was prescribed medication for muscle spasms. Mary experienced the fear, discomfort, and disruption that any reasonable person would experience after a wreck, and more, considering the defendant's actions following the wreck. The law does not require a permanent injury for you to award damages to Mary for her pain and suffering. It requires that the pain and suffering be real, and here it was. So we ask you to award damages for Mary's pain and suffering that reflects the full value of this event, not a nominal sum that the defense suggests that treats this as an inconvenience. An award in the range of $5,000 to $10,000 for her pain and suffering, combined with the full $10,604 in medical expenses. That's fair, proportionate, and in line with the evidence. As mentioned before, in this case, because of the defendant's willful, wrongful, and egregious conduct following the wreck, you're authorized to impose punitive damages against the defendant. The defendant struck Mary's vehicle, recognized that a collision had occurred, and then drove away, continuing without stopping, without checking on the people she had just hit, and without providing any identifying information. A hit and run is not an accident. It is a second, independent decision made after the collision. A choice to prioritize one's own interests over the safety and welfare of the people left behind. The defendant didn't know if Mary was okay. How could she? She didn't find out. She didn't stop to find out. She left 2 young people alone late at night after striking their vehicle at a speed that Mary estimated to be 30 miles an hour. This was not a panicked, reflexive decision. It was a willful, knowing, and deliberate decision. A panicked driver doesn't back up, wait for a green light, accelerate out of the intersection, and then speed up when someone follows them. Those are a series of knowing and willful choices of someone attempting to avoid responsibility. At no time following the wreck did the defendant call the police, report the collision, or return to the scene. Only because of an eyewitness who was willing to help was the defendant identified. She attempted to evade, and her decision to flee is precisely the wanton indifference that punitive damages are designed to address. Imposing punitive damages here sends a message that our roads are not a place where after you cause a wreck, you can decide that it's inconvenient for you to stop and suffer no consequence beyond a traffic fine. So we ask you to award punitive damages in an amount that is sufficient to deter this conduct and to tell the defendant and everyone watching this case that leaving the scene is not an option. So we've asked you to return damages to Mary for her medical expenses and for her pain and suffering. Now we're asking you for punitive damages. We suggest that you double the number that you've awarded Mary for her medical expenses and pain and suffering and return a verdict for punitive damages between $30,000 and $40,000, which represents twice the harm that the defendant caused. The full measure of justice for Mary is $10,604 for her medical expenses, $10,000 for her pain and suffering, and $40,000 in punitive damages, for a total verdict of $60,000. Mary was stopped at a red light. She did nothing wrong, and she deserves to be made whole. Thank you.
Okay, so we've listened to both arguments. We're going to take a poll, and this poll is going to show up on your computer. Give me a second. Okay, you have 4 questions here. One is the question about medical expenses. The second is pain and suffering. The third is if, yes or no, you would award punitive damages to Mary. And question 3 is if you answered yes to question 3, how much would you award her in punitive damages? So take a couple of minutes if everybody could answer those questions. Okay, I'm still waiting for answers from 2 people. Almost there. Yeah, Christiana.
I feel stupid. Where do I put the answers in at?
Okay, so did something not show up on your phone? I mean, on
I'm
your
on
screen?
the computer.
You're on a computer, a laptop?
Yes. Yeah.
Okay, so it should just show up on your screen. Can anybody on a I've never actually been on y'all's end and had somebody give me a poll. Go ahead, Brandon. Help us out.
What you mean, the laptop? I'm on a laptop. It popped up right in front of you, like, and that was it. And then you just went ahead. Maybe if you minimize Zoom to see if it's behind the app.
Yeah, let me see. No.
Okay, well, what I'll do is I'll just go ahead and end the poll, and then I have to pull up the answers anyway. And what I'll do is I'll go through the questions and I'll ask you, what your answer is, because we're going to go through all of these. So we're in a discussion portion now. Okay, all right. So we're going to start with, okay, Kathy, you said you would award just $495, which is what she owed after her insurance paid. And why is that? Can you tell me more about your decision there?
Sure. For her medical bills, all she was actually out of pocket was the deductible, and my amount might be off. I thought it was $495, and her medical insurance covered the rest. So I don't think it's fair to charge the defendant more than Mary actually paid.
Okay. All right. Thank you for that.
You're welcome.
So it looks like most of y'all are, around her co-insurance amount, actually. You kind of decided that she should be reimbursed only for the portion that she was out of pocket, except for Brandon. Brandon, tell me why you think it should be the full $10,000.
I'm not sure how like Discovery or whatever you would call it works in terms of finding out how much her insurance company paid, but that doesn't seem relevant in any kind of way in terms of the information she would provide in terms of what is the bill, for this the care that she received. That's pretty much the main reason.
Okay. All right. So if you were to argue that to anybody else, how would you convince them that they should reimburse her? Just that it's irrelevant how much the insurance paid and how much not?
It's irrelevant, not in a flippant way, but the idea that, so it would all depend on how the information about how her insurance works gets out, because you don't know if she's paying a deductible. You don't know if she may not even have insurance. That's kind of strange to me, that information. I mean, of course she can provide it, however the means are, answering whatever questions and stuff like that. But I still think the access to that type of information, like what's coming out of pocket, what did she pay out of her wallet, out of her own funds, doesn't need to be involved in terms of how much did her care cost.
Okay.
Yeah.
Does anybody agree with that now that they've listened to his argument? Do you think maybe you would change your number at all? No? Looks like everybody's still at the co-insurance amount. Okay. All right. Now we're going to look at punitive damages real quick. It looks like we have, let's see, Kathy, Sarah, James, Kayla, Shelly, Guest. I don't know who Guest is. Brandon and Glenn, y'all all put yes. But Wes, you put no for punitive. Can you tell me more about what your thoughts on that?
Actually, I changed my mind. I thought I had gone in and updated that.
Okay, well, I'll change it to yes. So you would award her.
Right. I think I said 1,000 or 2,000, whatever it was that the defense attorney mentioned. I think that was fair.
Okay. All right. Terry, you had your hand up.
I'm sorry. I did vote yes. You didn't call my name.
Oh, you're guest on here.
I'm guest. Okay.
Yes, you're guest. So now we know. Okay, great. And you said
you.
$500. That's right. Is that right?
Yes.
Okay. So now we had, let's see, Brandon, you said 10,000, and let's see, Kayla, you said 10,000. Kayla, tell me why you think 10,000 for punitive damages. What's your thought there?
Well, because initially for the first question, I put the co-insurance payment amount, but then that was just like my backup to it was like, well, that would be how much she should pay in punitive damages was the full amount of the cost of the medical care.
So you just, you saw that number and you're like, well, that sounds good for, okay.
It makes sense to me.
Okay. So
because she still needs to be punished because she shouldn't have left the scene, or she should have at least called or something. Like for her to not call or anything, she just didn't have any care about it. So she needs to be punished so she won't do that again.
What did you think about the attorney's argument of like double? like using the double number, you know, and doing.
I think double's a little extreme because the accident really wasn't that bad of an accident. Like if it was, but I mean, then again, truly it was an accident, so it should be something. But double was a little extreme for that minor incident.
Okay. Ayan, you said no on punitive. Tell me more about your thought process.
I honestly don't think that the severity of the accident justifies any sort of punitive damage. I really do believe Peggy's side of the argument when she says that she thought they were just leaving, because in an accident, I would have assumed that they would be, you know, they would pull over to the side of the road, toss their hazards on, because I feel like that's what you're supposed to do. If I saw them move on and then move into a gas station or whatever, I'd assume that, you know, this was not that bad of an accident. It was tiny scratches. I would assume that they were going home. That this kind of collision didn't really that they maybe thought that this kind of collision wouldn't really justify getting out and exchanging information, because it very well could not have. There might not have been any scratches for this kind of collision. I think that at best she was acting with negligence, which according to the relevant statute isn't enough to award punishments. I don't think she was acting with wantonly or destructively. I think that's all a little extreme. Negligence I can see, but according to the statute, that's not enough to justify punitive damages.
Okay, so anybody who said yes, which is actually everybody else at this point, do you have anything to say about that? Like anything to say about his argument that he just used? Brandon?
Well, I disagree with the plaintiff's lawyer's statement as far as whatever Peggy's excuse was. I mean, okay, and I've been wondering why no one's mentioned this, like in terms of lawyers or anything, and it could be just some wrong information. But that street, that part of the street that she hit the car on, that was the right turn lane. So she's either frantically leaving a scene, crossing a street in the wrong lane, or just not using her brain to say, I've interacted with another car. Oh, I'm sorry. And to specifically get to what he was saying, the idea that, well, yeah, I disagree with Peggy. I think there's evidence to show that she didn't just think someone was leaving, you know, everything's okay after you hit their car, as well as the one witness. I don't know if she was considered a full witness, but she got the license plate. She even said that it looked like Peggy was fleeing. She was driving really fast. On top of the fact that, like I said, unless I'm wrong, to cut in the way that she did to cross that street, to cross at the light, she had to cut another car off. So I'm really confused as to why nobody's bringing that up in terms of, you did a getaway. Like you went straight in a right turn lane. You obviously cut someone off because they were able to follow you, and none of that's mentioned. And so that's one part. I don't want to keep talking unless you want some more info, but
okay.
Yeah.
So, well, let me share my screen real quick, and I'm going to show you where those vehicles were. Now,
They weren't in the turn lane.
yeah, they weren't in the turn lane. When I took you
That's my
through
mistake. Sorry about that.
yeah. So they were actually in this straight. And then what happened was this is what happened. You know, V2 moves over into a turn lane. And then when the light turns green, then they both leave the intersection. V1 going straight, V2 going right.
And just real quick, thank you for correcting me. I do apologize for that, because
That's
I
okay.
really thought. But so even more so, back to what the gentleman said, Ayan, in terms of, okay, maybe it was a fender bender. One, that's not the protocol for any state in terms of interacting with another car, even if you hit a parked car. You know, I don't know what the parameters are for leaving your note or wherever that is, but it's not normal. I don't think a reasonable person would say, oh, I interacted with another car with people in it. Since they're driving off, I don't have to worry about it anymore. I don't think that's the reasonable once once you re-showed that image, they were already in one lane together. So the person who was hit decides to not go in the same direction that they were going because of that interaction. I think a reasonable person would also follow them. And so I don't really, I mean, for Peggy to see that car that was going in the same direction as she hits, and then it changes directions. A reasonable person would think, oh, they're going to check out the damage. Oh, maybe they want to stop. Even if Peggy could have been kind of fearful, she still didn't call anything, she didn't report anything, but that's where I am.
Okay. All right. Yeah, Terry, what do you have to say?
Okay. I agree with what Brandon's saying. However, it's not worth $10,000. I mean, come
Okay.
on.
For punitive, you don't think
Yeah.
it's worth?
No.
Okay.
No.
Yeah,
We-
Kayla. Oh, go ahead, Terry. Did you have something
No,
else to
I
say?
was just going to say it was just could be an error on her part. We don't know.
Okay, so I'm going to pull up your number real quick. I'm trying to find out where I put it. So Terry, you said 500 in punitive. So you think that's enough to punish her for leaving the scene of the accident?
Yes.
Okay. All right, Kayla, what did you have to say?
I think that the punitive damage part is supposed to be the amount of like what it's valued at, like what it's worth. It's about like her getting the point of a punishment for what she did. So I don't think it's about like the amount that the damage was or the amount of issues caused. I think it's the simple fact of her fleeing the scene of an accident and what message is supposed to send to the public about what if they would do the same thing.
All right, Christiana, I would like to hear from you. What about punitive for you? Yes or no on
So
punitive?
I kind of agree with everyone. Any normal any normal person with proper morals would have stopped, or they would have went and followed after them. Because you don't know, even if they just ding the car, you don't know what's going on inside. What if, God forbid, the passenger smacked their head on the dashboard? So now there's now a medical emergency. You don't know.
Okay. So how much do you think would you award punitive damages for her fleeing the scene?
I would say maybe like 5,000.
Okay. So yes. And I'll just write that down. All right, Glenn, haven't heard from you. Tell me what your thoughts are about punitive damages.
Yeah, I put 3,000. I just felt like that was a good sweet spot. It's obvious that she knew what she was doing because she had to make a valid choice one way or another to either stop or to drive. So unless she's 8 years old, I'm just gonna say her being an adult makes me believe that she was very active in the choice that she made. And if she wasn't, then I would assume I would have seen something along the lines of like some sort of psychiatric report. Maybe she didn't take her meds. She's crazy in some way, out of her mind. I didn't see any of that. So I'm made to believe that she's I don't want to say completely normal, but just in her right mind. You know what I mean? Because
Sure.
I am empathetic to people who do actually have things that are really going on, but nothing was said about anything going on. So when I look at that, I think, okay, so you made a valid choice to have an accident and keep going. As was mentioned earlier, anything could have happened. In the other car, it could have been that the vehicle was just struck in a way that somebody in the car could have got, whatever serious injury. Not every fender bender is just a simple fender bender. Some fender benders, even though it looks like that from the outside, I've seen people say like, oh man, I was completely fine, and then now I've got neck issues or back issues or
Right.
whatever. So I don't even want to use that as an excuse. Like, oh, it's just a fender bender. It's like, yeah, I've seen, especially with I feel like I've seen more cases, especially like with seniors, where that can be like a major issue. Just the smallest thing can have the biggest
Sure.
impact.
Yeah.
So yeah, in conclusion, that was the reason why I said 3,000. I just thought it was a bit egregious to maybe go to 5 figures, but I thought 3,000 is enough to, yeah, just to make her understand, feel it, and not do it again. Because I wouldn't want that to happen to anybody here.
Okay, Kathy, I'm to you. You agree on number with Glenn, $3,000. Do you have anything new to say? Anything nobody's mentioned yet about punitive and why you would award it?
Not really. I agree with the fact that, I mean, it was obvious that the person she hit had changed lanes and they were just going to the next available spot. I could see them not pulling over at a light because you're just going to be blocking traffic and possibly causing more issues. So I do think that, I think her name was Peggy, should have just assumed to follow the person she hit, make sure everything's okay, and, go from there. The fact that she didn't do that and she didn't even call 911 to report the accident led me to believe she did know, in fact, that she was fleeing. So I didn't go very high with punitive, but I thought 3,000 was, like he said, a good sweet spot. It wasn't so high to be, you know, way out there, but it also wasn't so low. I think that the defending attorney had said like 1,000. I thought that was a little bit too low for her willfully leaving the scene.
Okay. All right. Jermaine, Sarah, and Shelley, I haven't heard from y'all. So if you could give me about a 30-second sum up of why you said what you said.
I kind of agree with a lot of what everybody else has already said, that I think she needs to be held responsible and have some kind of repercussion for leaving, because I don't know that very many people who hit another car just decide to go off. Even if you were involved in a hit and run, you still would pull off and check your car and try to see if anybody else is around that saw it. You wouldn't just, oh, okay, I'm going to go home. It's all right.
Okay.
So,
all right.
I mean, I gave 2,000. I just doubled the number that they had asked for it. But I don't know. I don't think she should get away with it for nothing.
All right. Jermaine?
I think I gave 1,000 on that one, I believe. And I was gonna give her like 4 something too, like what the lawyer had stated. But I said I'd just be nice and give her 1,000. But like everybody else said, she definitely responsible due to the fact that she left. Basically like a hit and run. She didn't stop none of that. She fled the scene. So she definitely responsible for it.
Okay. Shelley?
I pretty much agree with everybody else. I went along with the I think I put 500 and then 1,000, and the punitive. I think I put 2,500.
That's right.
Okay, my thinking was when I saw the collision, it was they were in the lane to move to continue on through the light. When Peggy saw that because they weren't in the turn lane to begin with when they were hit, so and there was no blinkers or anything to show that was their initial intention. So my thinking was, okay, Peggy, they're pulling off for a reason. I need to follow them. And I agree, it's a hit and run. If you're not going to follow them, pull over, find out if everybody's okay, check your own vehicle, you're not concerned about it, it's an accident. Okay, I understand that, but it's still, it's a crime.
Okay. Okay.
And needs to be taken care of.
Great. Thank you so much. Has Ayan, have you changed your, do you think punitive or no? Yes or no?
But I would want to refine my argument a little bit, because I don't think anyone here,
give me
including
just
myself,
about 30 seconds.
Okay, well, I don't think anyone's saying that what Peggy did was right, because obviously it wasn't. What I think is the real argument here is whether this is recklessness or negligence. And I think from hearing everyone else's arguments that you would agree with me that it seems more like negligence than recklessness. And according to the statute, we're not making a moral argument here, we're making a legal argument. And according to the law, negligence isn't enough to appoint damages. Like, yes, she was wrong, and yes, she should have done something differently. But according to the law, this is not something we can fine her over.
Okay. All right. Thanks for that. This question is for everybody. Is there anything else you would want to know about this case? Yeah, Brandon.
How much weight does is it an eyewitness account, the lady that got the license plate? How much weight is there in terms of her testimony? Because I can't just look over the fact that she said it looked like the lady was speeding away.
That's up to you as the juror.
Oh, okay. I didn't know if that had any, like, did she, like, how is she registered in the case? Like, did they go out and seek her testimony? Is it just a kind of hearsay? Like, what
she brought the license. She followed the car, like she said. brought the plate number back, and then gave a statement to the police.
Oh, gave a statement. Okay, there you go. So I was just wondering, yeah, I think I also would say I'd lower my amount, my punitive amount to 5,000, but the 10 is fine. But yeah, that's all I want to know as far as the eyewitness.
All right, Kayla, anything?
I just think it would have been kind of relevant, like to know, like if there was insurance involved, like I mean, but you said that wasn't part of it, but that would have been good information to have as far as like making a judgment on what actually happened, because that could have been reasons for people reacting the way they did or how that happened. But it's also irrelevant for the situation though.
Okay. All right. All right. I'm going to share my screen. Oh, wait.
I have just quick. Do we know if she was criminally charged for leaving the scene, and did she serve any jail time, or was she fined? I think that kind of plays into it as well, to know on the criminal side what happened, because there was an arrest warrant issued. We saw that, correct?
Yes. Originally, she was arrested, and then her charge was changed to something else. I don't remember what it was. Ayan?
Okay.
Am I saying your name right?
Okay.
Ion. But
Ion.
yeah, you're doing good. I would want to know for the expenses if an itemized bill was ever obtained, because $10,000 for care that amounted to essentially an ibuprofen seems kind of ridiculous to me. And pro tip, if it's not what you do already, but you'll always ask for an itemized bill, otherwise you pay $60 for a Band-Aid. And I want to know because I think if you ask for an itemized bill, if one hasn't already been asked for, you'll find that the actual bill would be much lower.
Okay. All right, great. All right, I'm going to share my screen, and we're going to start our second case. So at this point, forget everything we've just gone over. We're on a totally new case. Terry, yes.
Did we decide pain and suffering?
I got your numbers, but
oh, okay. So
yeah, we're not going to discuss that.
Okay.
Yeah.
Okay.
We just don't have enough time sometimes.
Perfect. Okay.
Okay.
Thank you.
All right. So, all right. Now, so like I said, forget everything that we just went over. We're starting a totally new case for the rest of our time together. So this time your job is to review the evidence and to assign fault between the plaintiff and the defendant. So this again is a totally different case. We're going to listen to a case narrative and review evidence. So let's get started. On August 26, 2025, at approximately 2:50 p.m., at a McDonald's, Miss Lewis was working as a DoorDash driver. It was storming outside when Miss Lewis arrived at the McDonald's, parked her car, and went into this entrance that you see. And because it was raining outside, she was walking slowly and being more careful, like she does when she's driving on a rainy day. As she entered the entryway or vestibule, Miss Lewis slipped and fell on standing water on the floor. She landed hard on her right knee and was not able to get up immediately. While still on the floor, she took out her phone and recorded video showing the standing water in the entryway. At the time of her fall, there were no wet floor signs and no floor mats in the entryway. So we're going to watch this video.
So I just fell in McDonald's and there's no wet floor sign in the entrance, as you can see.
Okay, I'm going to replay this for you because sometimes it takes, a few times to kind of take everything in.
And there's no wet floor sign in the entrance, as you can see.
And one more time.
So I just fell in McDonald's and there's no wet floor sign in the entrance, as you can see.
Okay. A store employee saw Lewis and said he would get to the general manager, Diana Bowers. On the way, he met Bowers, who was in the back office at the time working when she saw Lewis on the floor through the security cameras. Bowers told her that a woman had fallen. I'm sorry. The employee told Bowers that a woman had fallen. Bowers went to Miss Lewis, and asked if she was okay. Miss Lewis said yes, but that her knee hurt. Lewis said no when Bowers asked if she wanted her to call EMS. Miss Lewis called her mother and told her she had fallen. Her mother asked if she was okay and if she needed to go to the hospital. Miss Lewis said she was okay and didn't need hospital care. After the call, Bowers asked Lewis again if she wanted help. Lewis declined. Bowers stood by while Miss Lewis got up on her own and walked to her car. Bowers later noted that it had been raining and the ground outside was wet. About 30 minutes later, Bowers saw on the camera that Lewis was still outside and sent an employee to check on her. After some time, Bowers saw the employee was still with Miss Lewis, so she joined them. Lewis told Bowers that her knee hurt, she could not drive, and she wanted EMS called. Bowers called 911 and her manager. The manager told Bowers to take pictures and to get a statement from Lewis. Bowers directed EMS to Lewis upon arrival, and Miss Lewis told EMS that her knee was in so much pain that she couldn't drive herself to the hospital. EMS told Lewis to move her car because it was not in a parking spot. Lewis moved her car to a parking spot and then walked back to the ambulance. EMS did not bring out a stretcher and told Lewis to climb into the back of the ambulance by herself. EMS then told Bowers they did not consider this an emergency. Lewis could have driven herself to the hospital, and they would note that she was ambulatory, meaning she drove and walked. All right, we're going to take a look at some photos. So again, this is the McDonald's. This is actually from Google Maps, and it's dated August 2019, but that is the entrance that she went into that day. This photo was taken by Bowers for her manager after the ambulance arrived. This is the same entrance that Lewis used to enter McDonald's. So I'll let you kind of take that in. This photo, again, was taken by Bowers for her manager after the ambulance arrived. This is a photo of the vestibule where Miss Lewis fell. It was taken after Bowers mopped the floor and put up the wet floor sign. All right, this last photo was taken by Bowers for her manager after the ambulance arrived. This is a photo of Miss Lewis with EMS personnel. Miss Bowers, about 4 weeks after the accident, gave a statement. And in her statement, she said prior to the accident, she moved the wet floor sign out of the vestibule for a spill elsewhere in the store. The vestibule, she also reported that vestibule floor was dry and it was not raining when the sign was moved. And she said this McDonald's location, and she's worked there 5 years, has never used floor mats in general. All right, so then after Miss Lewis went to the hospital, she received a CT scan. I'm sorry, she had an MRI of her right knee, which showed it had been struck hard enough to cause soft tissue tearing in the tendon above the kneecap, widespread inflammation inside and around the knee joint, fluid buildup inside the knee, and visible swelling on the outside of the knee. These findings are consistent with a traumatic slip and fall. The MRI did not show torn ligaments or a torn meniscus. Okay, so we're going to listen to Miss Bowers' deposition.
When would an employee remove a wet floor sign?
Oh, sorry. I need to fix that so you can see this full screen.
When would an employee remove a wet floor sign even though the floor is still wet?
Still not working. Let me pull this up elsewhere.
What is that supposed to be? Is that
This is a deposition. So this was done with the attorneys present. And Miss Bowers, who's the general manager, is asking questions to the plaintiff attorney. So you'll have to give me a moment just to pull it up. I don't know why it's not coming up.
When would an employee remove a wet floor sign even though the floor is still wet?
They shouldn't move the wet floor sign. I don't have it where they can take the wet floor signs up off the floor and then go put them in the utility closet. I don't do that. I leave them out.
Okay.
I don't want, if it's dry, I still want them out.
Every hour? Okay. So on the day of Miss Williams' fall, is there any document that reflects, when the entryway floor was last inspected?
No,
Okay. Does the weather conditions affect whether or not you put a wet floor sign in the vestibule?
no. I always leave a wet floor sign in the vestibule.
Okay. When it does rain, what typically happens to the floor in the vestibule?
When it rains, you'll have footprints in from customers that come in, but we dry mop.
Okay. How often do you dry mop?
When we have rain, we do it often. I'm not sure how often, but I try to send them out there often.
Okay. Do you have any documentation or checklist that shows that, them dry mopping when it rains?
No.
When you moved the wet floor sign out of the entryway, were you ever going to put it back?
Yes,
Okay. Why?
because I always have a wet floor sign in my vestibule. I was going to put it back. I just needed the spill cleaned up first.
Okay. Even though the floor was dry?
Yes,
Okay.
even though the floor was dry,
Why is that?
because I always had my wet floor signs out in the vestibule.
Okay. So what was the time frame from the time you removed the wet floor sign out of the entryway to Miss Williams' fall?
I'm not really sure around the time. I'm not sure. But it couldn't be no more than 15, 20 minutes.
Did any other customers go through the entryway after you removed the wet floor sign?
I'm not sure.
Did any other customers go through the entryway before Miss Williams' fall?
Yes,
How many?
I'm not sure, but I did have some customers come through that door.
Okay. Are you able to rewind the camera?
Yeah, I can, but I don't have the password. I have to call my supervisor for the password.
Okay. Are general managers allowed to have the password to rewind or access? They are?
Yes.
Okay. How often do you rewind the camera?
Review my cameras all the time. Especially on night shift, all the time. See, it's set up on my phone, so I
Okay.
don't have to put a password in on my phone to rewind so I can see it. But at the store, I have to have the password. I don't know the password because it's already in my phone when they set it up.
Ah, got you.
I don't know it to play backwards on
Okay.
the screen in the office.
Can you access through your phone? Like, do you have to be on site to access the cameras on your phone?
No.
Okay.
I don't have to be on site.
How far back can you rewind on your phone?
A month, 30 days.
Okay. So then when was the last time someone checked on the floor in the vestibule after you removed the wet floor sign?
I'm not sure the time frame, but the lobby was getting cleaned, like I said, within those 20 minutes, 15 to 20 minutes. And while he was cleaning the lobby, she was on the floor in the vestibule.
Okay. And then you went into the vestibule to check on her?
Right.
Okay. What was the condition of the floor when you entered in and she was on the ground? Miss Williams was on the ground.
Just her footsteps. The floor was still dry. There was not wet, just the water that she brought in.
Okay. Was there any pool of water
No,
on the floor?
no,
There was no standing water on the floor?
no.
When would an
I muted myself. We're at the argument section again. So we're going to review quickly what's called premises liability, and then we're going to view the arguments by the defense and the plaintiff, and then we'll take another poll and we'll have another discussion. So Georgia premises liability law states that a landowner who invites others onto the property must use ordinary care to keep the premises and approaches safe. Rainwater alone does not automatically create fault to the landowner. In a rainwater fall case, the plaintiff must prove the fall was caused by an unusual accumulation of water, negligent inspection or maintenance cleaning procedures, and the defendant's superior knowledge of the hazardous condition. The plaintiff cannot recover unless she shows that she lacked knowledge of the hazard despite using ordinary care. Okay, so let's listen to the defense.
The plaintiff, Miss Lewis, was in a hurry when she slipped and fell at McDonald's. It was not the fault of McDonald's that she fell, but rather it was Miss Lewis's own carelessness that caused her to fall. In addition to that, McDonald's is not liable to Miss Lewis for the following reasons. First, I want to point out that Miss Lewis was not even a customer at McDonald's when she fell. In fact, she was working for DoorDash when she fell. She was probably in a hurry. She was rushing. She was wanting to get in and get out. She makes the same amount of money if the delivery takes her 10 minutes or if it takes her 1 hour. That's DoorDash's economic model. The more you can deliver, the more you're going to make. So of course Miss Lewis was in a hurry when she went into McDonald's when she slipped. She wasn't paying attention. She was, again, trying to get in and get out. So it's Miss Lewis's own carelessness that caused her to fall, not the rain that was falling outside. And thus, it's not McDonald's responsibility, and McDonald's is not liable to Miss Lewis for her fall that she caused due to her own carelessness. Even more than that, the law's clear that a landowner is not responsible to someone who slips on rain in their store. And the jury charge you're going to hear says, if you find the condition was caused by ordinary rainwater, or that Miss Lewis had equal or superior knowledge of the hazard, you're not authorized to find McDonald's liable. Miss Lewis knew it was raining. She had equal, if not superior, knowledge to that of McDonald's. So I know the law seems to favor landowners over ordinary citizens, but the reason for this is that because during rainy water, it is expected, or some water is expected, to be where people enter and where people walk. The law does not require that McDonald's continuously monitor that, continuously mop up rain that's been tracked in. Some accumulation of water is expected, and that accumulation of water by itself is not an unreasonable or an unusual risk. It is instead a condition that those who go out in the rain should expect and should anticipate. Under the law, Ms. Lewis is charged with equal knowledge that the water may be present in areas frequented by people who are coming and going. So McDonald's can't be held liable for that reason. Ms. Lewis hasn't proven that there was an unusual accumulation of water, and McDonald's failed to follow some sort of protocol or inspection procedures. She's also not proven that she lacked knowledge of the rain. She knew it was raining. She got out of her car. She was driving in the rain, and she had water on the bottom of her shoes as she walked into McDonald's. That's what caused her to slip, not some unusual accumulation of water. If there was really that much water on the floor, she should have seen it, and she would have avoided it altogether. Now, finally, the mere fact that she fell does not make McDonald's responsible and does not create liability. The question is not whether Ms. Lewis was hurt, but whether McDonald's failed to exercise reasonable care. Ms. Lewis has not proven that McDonald's was negligent and is thus not entitled to recover. So for these reasons, the verdict should be for the defense. Thank you.
Okay, now we're going to hear from the plaintiff.
Thank you for your time and attention throughout this. I want to walk you through how the evidence fits the law that was just given to you. This case is not about holding McDonald's responsible simply because it rained. The law does not require that. This case is about ordinary care. It's about whether McDonald's knew or should have known that water was accumulating in its vestibule, and whether it took the reasonable steps to protect its customers. A business that invites customers onto its property has a duty to exercise ordinary care to keep the premises and approaches safe. Now, when rain is involved, the law recognizes that a business is not automatically responsible for every wet floor or every wet footprint or every drop of water on the floor. But fault may exist when there is an unusual accumulation of water and the business is negligent in inspecting the floor or maintenance, or when the business has superior knowledge of a dangerous condition. And that's what the evidence shows here. Let's start with what's not disputed. They're facts. McDonald's admitted that there were no floor mats in the entryway on the day of Miss Lewis's fall. Not temporarily missing floor mats. There simply just were no floor mats at that location. McDonald's also admitted that it was raining that day. And the general manager, Christina Bowers, confirmed that when it rains, customers track water into that entryway. It comes in from their shoes and when they open the door. McDonald's also admitted something that's very important. The wet floor sign that had been in the vestibule before Miss Lewis's fall was removed. It was not moved by a customer. It was not misplaced by accident, but the general manager removed it because there was a spill near the drink machine in the lobby, and she decided to use the closest wet floor sign available. That one happened to be the one in the vestibule. So the question is simple. What condition did McDonald's leave the floor in the vestibule in before Miss Lewis walked into that store? McDonald's is going to ask you to see this as a case about a few wet footprints and that Miss Lewis tracked in walking into the entryway. But the evidence points to more than that. For 15 to 20 minutes before Miss Lewis entered that store, customers continue to open the door and walk through that same vestibule while it was raining outside. Those customers brought in the water in from the outside. There were no wet floor mats to absorb that water. And also there was no warning sign since it had been removed. And no employee was assigned to check or maintain the vestibule during that time. That is how standing water accumulates. Just steadily, because customer by customer comes in, opening the door in the entryway, and McDonald's knew that, rainwater tends to accumulate when that happens. And in this case, you don't have to guess whether there was water on the floor. Luckily, Miss Lewis took a video immediately after she fell. And that video shows a significant amount of standing water in the entryway. It was not just a damp footprint. It was just not ordinary rainwater on the bottom of someone's shoes. The video shows the condition of the floor right after the fall, before anyone had a chance or time to change the scene of the fall. That's very important. Now, McDonald's is a business with cameras. The general manager testifies she was watching the cameras, but McDonald's doesn't have video of the fall. McDonald's does not have video showing you the condition of the floor in the vestibule minutes before Miss Lewis's fall. And McDonald's cannot show you a video proving that the floor was dry in that vestibule, or that there was only a harmless amount of water on that floor, or that someone came in and inspected the floor before Miss Lewis walked in. You may consider those facts. I'm not asking you to speculate, but I'm asking you to look at the evidence we do have. The video taken immediately after the fall, the testimony that customers had been walking through that vestibule for 15 to 20 minutes, the absence of floor mats, the removal of the wet floor sign, and the fact that the area was mopped immediately afterward. Those facts are very important. When Ms. Bowers, the general manager, was asked under oath, whether the water had been building up in the entryway that day, she said she can't recall if it was filled up with water. That matters. The general manager, who was responsible for the store, cannot tell you the vestibule was dry, that the floor was dry. She cannot tell you it was safe. And she cannot tell you that another employee came and checked it before Miss Lewis fell. And McDonald's has not produced any video showing otherwise. You also heard what happened immediately after the fall. The maintenance employee came in and mopped the vestibule after Miss Lewis fell. That's pretty common sense. You don't mop a floor because of one or two harmless footprints. You mop a floor because it's wet enough that it needs to be addressed. The law also instructs you to consider the amount and visibility of the water, whether the accumulation created an unreasonable risk of harm, and whether McDonald's had actual or constructive knowledge of the condition. On those points, the facts are pretty straightforward. It was raining. McDonald's knew that rainwater was tracking into the floor in the vestibule. Customers had been walking through that entryway for 15 to 20 minutes. There were no wet floor mats and there was not a wet floor sign, and it was removed by the general manager. Also, no employee checked that area before Miss Lewis's fall. More importantly, Miss Lewis's video shows that there was standing water immediately after she fell. And after Miss Lewis's fall, the floor was immediately mopped. That's not ordinary care. Constructive knowledge can be shown when a defendant or its employees were in a position to see and correct a hazard, and Ms. Bowers was in the building. The general manager was on duty that day. She was watching the store cameras. This was the customer entrance to the restaurant. It's not some hidden corner in the restaurant. McDonald's knew that rain created a risk in that area, and McDonald's had every opportunity to either leave a wet floor sign in place in the entryway, place wet floor mats in the entryway, or have someone continuously inspect and mop the entryway in the vestibule. Those were simple, reasonable steps. They're not expensive. They're not burdensome. They're just basic safety measures customers should expect from a corporate restaurant. We're asking McDonald's to be responsible for what happened inside its own front entrance after it removed the wet floor sign, after it decided not to have any wet floor mats, and after it allows water to accumulate in its entryway. If you find that the wet condition in the vestibule created an unreasonable risk of harm, that McDonald's had knowledge of that condition superior to Miss Lewis's, and that McDonald's failed to exercise ordinary care to correct or warn Miss Lewis, then the law authorizes you to find in favor of Miss Lewis. And therefore we ask that you return a verdict in favor of Miss Lewis. Thank you.
I do that at least once a session. I don't unmute myself. Your task is assigning liability between McDonald's and Miss Lewis. So you're going to give a percentage to each person. Whatever your total is, whatever your number is, those two numbers have to equal 100%. So let's say you want 25 to one party and 75% to the other, 50 to one party, 50 to the other, 0 to one party, 100 to the other. It just has to equal 100. Okay. So with that being said, I am going to share a poll with you. Christiana, are you seeing it this time?
Nope.
Okay. Okay, so I'll just read the question and you can again, I would assign what % of liability to Miss Lewis and what % of liability to McDonald's for Miss Lewis's fall. So you just think of those numbers. You don't have to tell me what they are.
Okay.
No yawning, Terry. You're going to set us all off. Okay, I'm just waiting for one more response.
Hey, I run go get my charger real quick. My battery's about to die. Okay.
Yeah, sure. Okay. All right. I'm going to end the poll. Give me a second to download the results. All right. Okay, I'm going to go through each person and I'm going to, I want you to kind of give me what your thought process was in assigning liability. Okay, so the first percentage that you give is for Miss Lewis and the second is from McDonald's. Kathy, I'm going to start with you. You said 25 to Miss Lewis, 75 to McDonald's. Tell me what your argument is there.
For Miss Lewis, yes, I do think that she has some responsibility. She knew it was raining, so you exercise a little more caution. That's why I gave her 25%. But as far as McDonald's, as a customer or someone walking into their store, I expect them to have the floor mopped and the wet floor sign up. And in most cases, the mat's down. And they failed to do all of that. And I feel that McDonald's should have more than one wet floor sign, that they don't need to move it from the vestibule to the drink station.
Okay. All right.
That was my thought.
Okay. Ayan? You said 15 and 85. So 15 Miss Lewis, 85
Yeah.
McDonald's.
Pretty similar reasoning here. I also do want to say that I think for Miss Lewis, that with her exercising like a proportionate amount of caution, I still don't think it would be reasonable for her to have seen the water, because one, it was pulled up right by the side of the door, and we saw the picture of the entrance. Right, there was a huge glare. Like, even though the door was glass, all you could really see is the reflection of outside. And I don't know very many people who would walk into any establishment and immediately look at their feet where the water was. Like, you might look at the floor immediately afterward in front of you, but I don't think it's included in that reasonable caution to look immediately at your feet when you open the door.
Okay. All right, great. Okay, Sarah, I don't think I understand your answer. So you're going to have to tell me what your percentages are. What percent for Miss Lewis?
I think I did 15 and 85 for the first question.
Okay, there was only one question. So I don't know why two showed up. So what percent?
I had answer 1 and answer 2.
Oh, well, that was how much for Miss Lewis, how much is she responsible, and how much is McDonald's? So that's Lewis and McDonald's. Yeah.
Okay. Then I misunderstood. So 15 and 25. I kind of agree. I think Miss Lewis has a little bit of responsibility, just because it's not 100%. I think McDonald's, I mean, she's a person walking into the establishment, but it would be very interesting to see the video. And why is the video gone?
Okay. So your percentage are, how much is Miss Lewis responsible for?
15.
15, and so that would make 85 for McDonald's. Okay,
Correct.
gotcha.
And
Thank
you
you.
could also see, even in the picture that they took after it was quote unquote mopped up and they put the sign, there was still water accumulating in that same exact area. So to me, that would say that there's like the building is compromised and that there's an issue there.
Okay. All right, Jermaine, you went half and half. Tell me why.
Because um I can't remember her name. But she deserves something because she fell inside of somebody's establishment. So and I gave 50 from McDonald's because I mean y'all gotta pay something because regardless y'all at fault also because somebody fell and got injured at your establishment regardless. So I just did 50-50, part of her fault and part of their fault. It ain't really nobody. I mean, she fell and at y'all established, so either way it goes, some kind of compensation got to be given regardless. So
Okay. All right, Kayla, you gave me some fun numbers, 18 and 82. Tell me how you picked 18 and 82.
Well, because I was gonna say 15% because she could have wore slip resistant shoes because knowing it was raining and knowing like her job is working for DoorDash. But I also feel like DoorDash should be the ones to be going after McDonald's about it because if she's employed by them, like why aren't they included in whatever is going on? Because they sent her to go work there, they didn't tell her what she needed to be careful whenever you go, that type of thing. So that's why I put the other 3% because she should have worn some slip resistant shoes because it was raining. But other than that, McDonald's is completely irresponsible, I think.
So you would want to know then if she is an employee of DoorDash or
or if she's an independent contractor or
Okay.
how does that work?
Okay, gotcha. All right. Okay, that leads me to Wes. You said 90, Miss Lewis, and 10. Tell me. Oh, you're muted.
Okay. Percentage at fault. Maybe I must have read the question backwards because I went 90% her and then 10% McDonald's.
Yeah.
No, I'm sorry. I answered it correctly.
Okay,
so
so you
yeah,
want
it's mostly
she's
her
90%
fault.
mostly her fault. Okay, tell me why.
You're right, and then 10% McDonald's. If you look at the pictures, that's not an unreasonable amount. The only wetness there really are her footprints. I mean, you can see it clearly, and I think it's a big exaggeration to be saying that it's full of all this accumulated water. Now it's kind of circumstances that she took the sign away because there was another spill for 15 minutes. But how much water accumulated in 15 minutes? And they said that it had already stopped raining. I don't know how long ago it had stopped raining because that dries up. You notice when
Wes, you're cutting out.
like that.
You're cutting out, so I'm gonna
Okay.
I'm gonna move to the next person. Okay, Shelly, you think it's 100% her fault? Tell me why.
Did you say Shelley?
Yes.
Oh, okay. I thought you said Kelly. I wasn't sure. But anyway, I'm not sure if I read the question correctly. But my thought process was McDonald's is 100% liable.
Okay, I'll switch that in there.
I did read it wrong. I'm listening to everybody. I'm going, uh-oh, I think I read it wrong. And the reason I say 100% liability for McDonald's is they are a business, they're a corporate business. They should have safety policies and procedures that should be followed consistently, regardless of the weather. And because of the people coming in and out prior to the lady that was hurt, you're going to have water on the floor. And I know that, as a customer, hopefully we're conscious enough of our surroundings to be more aware, especially if it's raining or snowing. But it's still a business, and customers are on your property and you're liable. And regardless, I mean, that's why and if you don't want to have issues, you train your employees to follow those safety procedures.
Okay, so would you want to know if there was like a protocol for how often something got mopped or, for cleaning procedures on a rainy day?
I'd like to know what their policies and procedures are. Yeah.
Okay.
I mean,
All
as
right.
far as policies, you keep it safe. I get that. Hopefully
Yeah, but the
that's
procedure.
but
Yeah.
the procedures on that. And
Right.
if it's raining considerably or if there's a lot of snow out there, well, then you do it more often. You
Okay.
know what? To keep
All right.
everybody coming
Terry,
in
I'm
and
gonna
they're
have
safe.
I'm gonna have to move on. I'm sorry. Terry, I'm sorry, Shelley. I had to move on. Terry, tell me, you said 50-50. Tell me why.
Okay. Well, when I heard the law read and it stated that there wasn't a harmless amount of water, there was just a little bit of water. So I think according to the law, there wasn't a huge accumulation of water, just a small, and she could have brought that in on her shoes.
Okay,
That's
so
just
that's
how-
why you said 50-50. All right.
Yes.
Okay, Brandon, you're 100% for McDonald's. Tell me why.
I really was looking at it from the decision that was made to not have floor mats in there. I mean, floor mats are ubiquitous. The carpet or whatever you use, something to help provide friction over a slippery surface. There's a reason McDonald's, as a franchise owner corporation, decided not to use those, and so there are steps they'd have to take to remedy whatever use you get out of those mats. Whatever prevention the mats are doing, you're going to have a process to ensure that you're still protecting your customers coming in from whatever you were protecting them from using them floor mats. I think there was a deliberate choice. So they are in control of that choice. And so if there's a process that includes have a wet floor sign out all the time, have a wet floor sign out, monitor, sweep, or mop. If there's a process that's done to make up for that lack of friction on a known slippery surface, and I forgot to say, McDonald's floors, they're known to be so slippery when wet that they almost, I'm pretty sure, require their employees to have slip-free shoes or slip preventative shoes. I'm not saying that you require that from your customers because you shouldn't.
Sure.
But
Yeah.
the idea
Just your
is,
employees.
right, but the idea is there's a knowledge that moisture or water on these floors causes more of an issue for your average person, and that the ubiquitous use of using floor mats help add friction to slippery surfaces. You chose not to do that. And so
Okay.
the processes that you choose to make up for that need to be followed closely. And if they aren't, it's never going to be the customer's fault. I can't be mad at you coming to my business, whether you're disabled, have one leg, two legs, three legs. Like, it doesn't matter because you want me there.
Okay,
And
Brandon, I'm
oh, go
sorry. I
ahead.
got to
I'm
cut you
done.
off. I'm sorry.
Yeah.
I got to get to Glenn and we got to get to our verdict. Okay, Glenn, you said 100% McDonald's.
Yeah, just to keep it brief, I gave 100% of the responsibility to McDonald's because, for one, it was mentioned earlier, but the only question I would have had is, well, where's the video? And I just think it's ironic that there is no video. I think they did the best they could from what it seems like in terms of asking her, like, oh, do you need help, and the call and all that. So taking that into account. But ultimately, I'm also thinking about a couple McDonald's that's around where I live, and I can say for a fact it doesn't look anything like theirs. Now I know it's franchise owned and all that stuff, but yeah, the McDonald's that I'm thinking of, and also other fast food places, it was mentioned about the rug. And then anytime it rains, maybe they went through a lawsuit like this, but I kid you not, every time it rains, there's like not even just one cone, but I've seen where it's like 3 or 4. And I'll just go up in there, just get like a sweet tea, just a little something for the road. But every time I have not seen it where it looked like what you showed us in the pictures, where there's no mats, there's no, thankfully they admitted that the cone was like somewhere else. So it's like, okay, so just spend $5-10 to get another cone or however much it costs. But yeah, that's what I say, and that's why I gave all the responsibility to McDonald's.
Okay, great. All right. So anything that stuck out to you or anything, anything else you would want to know about the case? Yeah, Brandon.
I noticed through some people's discussion, like the amount of water seems to be in question. Is there something that kind of locked in that yes, there was more water than just one person walking through? Like, is there some way, or was there some kind of uh uh definite or defined amount of water in that room? Like we saw when I think you even pointed it out, right next to the bottom of the front door, there's water there. I think maybe Ayan mentioned it too. You can see that. You can see someone's going to walk through that regardless of what's going on outside or further step. That's a lot of water that's there. Was there some, but it also seems like some people didn't notice it. So I didn't know if is there a definite
Sure.
amount.
Okay. I don't have an answer for that question. Christiana, you raised your hand and I forgot to get to your answers. So
Yeah, well,
tell
I
me your
want to say like 75 for McDonald's, 25 for her. Because they should have safety protocols, things like more cones, mats, and stuff like that, just reasonable things. Because like other people have said, how many other times have you gone into other establishments, whether it be a fast food place, a convenience store, grocery store, whatever, they've got mats. But then on the flip side for her, you kind of have to exercise some reasonable caution. How much did she? And I'm not trying to victim blame at all, but like, yeah, accidents do happen, but still, like, you know.
Okay. Any other things that y'all would want to know?
Why
Or
don't they have mats?
Yeah. It's a good question. That is a really good question.
That's what I was trying to say. I don't know if you can still hear, but if I'm breaking up or not, but that's kind of where I was going.
No, yeah, I can hear you now. Right. Yeah.
I would also
Go
oh,
ahead.
I'm sorry.
Go ahead,
I would
Sarah.
also like to know, like, kind of staffing wise, were they short staffed that day so there wasn't enough people to go in and mop every 15 to 20 minutes, or and the busyness of the establishment at the time, was it super busy so nobody was paying attention, or was it kind of a slow period
Okay.
where they could go and mop?
All right. Anybody else? Hang on.
Know if the fact that Miss Lewis is losing money on this plays into damages or fault at all, because the defense kind of touched on this, but she's a DoorDash driver, and the DoorDash model it's not a waged position. You're kind of reliant on tips and how quickly you can get orders in and out. So she is even in that half hour that she's debating, oh, should I get checked out or not, losing quite a bit of money.
Okay, Kayla, you had your hand up.
Yeah, that's what point I was gonna go back to. I would want to know, like, where does DoorDash fall in line there? Because I feel like they're responsible too to let their employees know, like, hey, when you walk into these restaurants, let's be wear slip-resistant shoes like the employees there do and stuff like that. I think that's pretty important.
Okay. Anybody else before I move on? No? Okay. All right. So this is the fun part. Turn your mics on, and y'all need to come to a decision, a consensus on percentage of fault or liability for Miss Lewis and McDonald's. So let me see. I'm going to make Glenn, I'm going to make you the foreman. All right. So
All right.
y'all go.
So to keep it simple, as far as everybody, I feel like there were like mixed numbers. I know that Heather had mentioned, but if you just want to speak anybody about a number, you know, even so to speak, for what, if not a number, my bad, like the percentage number, because I know that there was like different percentages.
I started at 50-50. After hearing everybody, I think I would go 25-75 and 75 at fault for McDonald's. From my
Let's just say,
50-50.
Yeah,
I think that's fair.
So you said 75-25?
Yes.
And
I
has
changed it
75
from
you said for
McDonald's.
no worries. Got you.
McDonald's.
So 75% McDonald's and then 25% for Lewis, correct?
Correct.
Got you. And then I heard somebody else agreed. Well, how many people, if you guys can just raise your hand if you agree with the 75-25 McDonald's versus Lewis, just so I can see
I think that's
everybody
fair.
agrees. So 1, 2, 3, 4, 5, 6, 7. Okay, so everybody keep your hands up really quick. I just want to see. I think there was only 2 people that didn't. So Brandon and Wes. Brandon and Wes. Okay, so Brandon and Wes, what percentage would you guys say that you think it should be between the two?
I'm more.
Well,
I mean, I'd settle for
Brandon and I are
75.
on completely different ends.
Oh yeah, that's what I thought. Yeah. You go
Yeah.
ahead, Wes.
Yeah, I think Brandon and I are kind of completely different. And I thought it was mostly
Mm-hmm.
her fault, being in a hurry, and it didn't seem like an accumulation. And it did seem like the manager was having the water dry mopped, consistently,
Mm-hmm.
and there wasn't that many people that came in. It was just an unfortunate timing with the sign. However, they should have more than one wet floor signs, for one. And two, if with a vestibule like that, they should definitely have floor mats. So that's the only reason why I would put McDonald's at fault. It kind of sounds like managerially and everything else, they were doing what was reasonably possible during the rain to keep it
Mhm.
dry, and it wasn't that. So I'd go up to 50-50, just to
Okay, so you're at 50%
even it
and
out. But yeah, I think it was more
50%.
of just unfortunate circumstances. Yeah.
Yeah, no doubt, no doubt. And then Wes, what percentage for you? So far we have 8 people, which includes me. 75% McDonald's, 25% Lewis. Brandon said 50-50, and Wes, what percentage do you say?
I'm Brandon.
Yeah.
I didn't say anything yet. Wes said 50-50.
Oh,
I'd
my bad,
say,
Wes. Yeah, thank you for that correction.
oh, no problem. No, I get it. I'm more on the line of it doesn't have to be 100% for McDonald's, but I would like it to be. But if 75 was the highest we could all get as a group, I'd be okay with that. But I truly think they're 100% at fault still because they chose to not have floor mats. Everybody knows that helps. Whatever reason, that's their business. But the idea is they acknowledge that there is a process they use to keep the floor dry for the safety of their people. And not just with her own testimony, the manager Bowers, it seems like that fell through. I don't care if it was a little bit fall off or a whole thing. The whole thing came crumbling down. Their process, that the power over what McDonald's does in their prevention and safety that has nothing to do with Miss Lewis. She's a customer, she's a worker. It doesn't matter. Water's there, and their process fell down, and that's it.
Got you. So just so you know, for the record, I was right there with you as far as 100% on McDonald's side, but also said the same thing you said, that I could accept the 75-25. So yeah,
Right.
I hear you loud and clear. So that would be 9 people then, and just to verify, hold on one second. 1, 2, 4, 5, 6, 7, 8, 9, 10. Yeah.
For
So
both you and Brandon, I think 75 is a good minimum, but I personally would also go up to 90 or even 100%. Really 100%,
got you.
but
I
Got you.
agree
And
with
then
that. Yeah.
Oh, word. So yeah, it looks like between 75-25 and 100-100, there's pretty much everybody in that same group, minus Wes. So Heather, to give it back to you, as far as this is concerned, is this one of those like everybody literally has to be in the same boat, or is it like majority rules?
Yeah, a jury has to come back with they have to have a consensus. So
Consensus or unanimous decision? I'm sorry to cut you off.
oh,
Yeah,
well,
that's
yeah.
basically what I'm asking. Like, does that be unanimous? Because Wes technically be the only one that's not in that camp of it could be 100% McDonald's, 0% Lewis, or 75% McDonald's,
So
and
Wes,
then
if you walked
25%
into
Lewis.
McDonald's right now and you were working as a Door Dasher and you just busted your behind right there at the doorway, you don't feel like they'd be 75% responsible? Like, I'm just wondering. That's all I'm saying.
No, that's a good question.
Well,
Wes, what do you have to say to
I'm
that?
personal responsibility. There should be reasonable care as well. And you're working; it's your job. There's safety protocols everywhere. You should know.
Follow up to that, what would you do to prevent falling, Wes? And you have a good point. Take care of yourself, protect yourself.
Slow
What would you
down
do?
and watch where you're walking, stepping.
Well, you're making pennies on every order. You know that you'll only make gas back if you get a good tip. Are you going to be taking that much extra time?
Well, we're talking steps here. It's really not that much extra time from the door to the vestibule.
You're
4
buying
steps to the
slip-proof
inside the next
shoes.
door.
If you're buying
Well,
slip-proof shoes, that's an extra
conversely, I don't
Slipproof
$50.
shoes only work to a certain point.
Mm.
And as to
conversely,
the
I'd
McDonald's
want to
requiring
ask you
employees to wear
though.
slip-free shoes, that's because of the oil buildup in the back. It has
That's
nothing to
true.
do with water buildup.
But the
Got
floors
you.
are
But
known to be
conversely, I
slippery,
do have
though.
a question for you, Wes. I do have a question for you. Just like what was presented to you earlier, the hypothetical scenario. You walk in and you're already saying like, "Hey, I'm gonna take accountability," which I get because I'm that kind of way too, where I'm like hard on myself, constructive criticism, love it more than compliments. I completely get where you're coming from, where you will point the finger at yourself first before anybody else. With that said, would you not also take into account that I know you've been inside restaurants, and so I know you know what I'm talking about, that it's kind of off that there's no rug and that there's no wet cones? Like, would you take that into account to alleviate that whole
Yeah,
like
yeah,
thing you point at
absolutely.
yourself?
Right. Those are the things that I'm taking into account most.
But not more than 50%. Like you
As
wouldn't be able
far as
to go to
McDonald's.
75.
Mhm.
You wouldn't be able to go to
I'd go to
75, like
75.
25%?
I'd go to
Oh!
75 for that. Right, right.
But in the pictures also,
Conventional.
even after they dried mopped, there was still standing water. Well,
No,
not standing, but there was still wet on the floor, even after they dry mopped. So if they
I
were
think
still dry mopping every 15 to 20 minutes, the floor was still wet.
Mhm.
I think
But
that
if
was a
you look
shadow
closely, that
actually
that
into the
was
tile.
condensation from the windows.
Yes.
That wasn't the door itself. I mean, there was a whole vestibule that where they did the picture. That was from the side. People weren't walking over
Mhm.
there. You know,
Mhm.
that's just the other side. And it looks like they had the air conditioning on, and it was all condensation from the window. It was probably real hot out, and that was all from the windows. So you know that would have to be consistently cleaned. And it sounds like that they were consistently dry mopping it. You know, so following the protocols, etc. But yeah, again, they should have had mats and an additional wet floor sign. So
Right on. All
Okay,
right.
great.
We got the band together. Everybody's ready. We on the 75-25 tip. You feel me?
Yes, this is great. All right. Wonderful. Okay, I've been processing your payments as y'all have been debating. I am going to throw up one more survey. This is the survey. It's to give feedback about me, the whole process. I would appreciate if you could fill out the survey. If you don't want to, that's up to you. But just check your phones and see if you've received payment. Let's see, Sarah. Okay, Sarah, you did get my message. Okay, I just was checking on that.
Just to confirm, I did receive it. This is
Okay,
Glenn.
great. So yeah, as soon as you get your payment, and please fill out the survey, you're free to leave. And I just want to thank you so much for being here tonight. It was a great pleasure working with all of y'all. And Glenn, you did a great job as the foreman. So
Yeah, you did a good job, man. I was like,
it
how are we
was
going to get this done?
I,
Yeah, that
I was
was
a little
really
worried
good.
there in the final hour. I was like, I don't know if we can get Wes on board, but no, it was a pleasure. So thank you
I'm
guys.
stubborn that way, so you guys should be proud of yourself.
Nice.
so much. Y'all
Right
have a
on. This was
great
fun, guys.
evening.
You too. Thank you.
You too. Thank you.
Welcome. And just so y'all know, I'm still here. I'm just processing payments still.
All right, you guys have a good one.
You too.
Have a
And
good
just so
one.
you know,
Bye,
Heather, I
Gwen.
submitted the survey.
Bye.
Thanks.
Okay, great. Okay, I've processed everybody's payments at this point, so.
Okay, I just got mine.
Okay, wonderful. Thanks, Sarah.
Thank you.
Thanks, Heather. Brandon, I
Thanks.
received mine. Hmm.
Okay, great. Thanks, Brandon.
Bye.
Have a good evening.
You too.
All right, just finished my survey. You
Okay,
guys have
great.
a good
Thanks,
night.
Sarah. You
You're
too.
welcome.
I just finished my survey and I got my payment. So thank you so much.
Wonderful. Thanks,
Have a good
Kathy.
night.
You too.
You're welcome. Bye-bye.
Bye.
How do you know if you got your payment?
Let's see. Shelley, check your Cash App.
Oh, okay. Hold on a minute here.
That's you sent me your Cash App, so that's how I paid you.
Okay.
Oh no, did I send my Cash App? Because mine is no longer working.
Oh no, you did not, Kayla. You sent me Venmo. So check your
Okay,
Venmo.
good, great. Okay.
Let's see where. Okay. Heather, there you
What?
are. Okay. Thank you. And I
Thank you, Shelley.
submitted.
All
Hope
right,
to
good
Great.
job
see
with the
you
survey.
soon.
Thank you, Heather.
Bye. Thanks, Wes.
Bye-bye. Let me see.
Hey, how did I get you my payment?
Rantre, PayPal.
Oh, okay. Did it go through?
Uh-huh.
Okay then.
I'll check it again, but you go, oh, bye. Go ahead and check it if you don't mind. I just want to make sure you got paid, but on my end, it said yes.
Well, Fleetwood Joshua.
No. It should say Heather McCrum.
No, I'm talking about what PayPal email I gave you.
Oh,
Yeah.
all right. Sorry about that. Hang on a second. Let me look.
I'm trying to look at our message. I can't even see it.
Let's see. What did you give me? Yes, Fleetwood Joshua.
Okay then, yeah, that's it. Thank you.
Okay, great. Thank
All
you.
right.
Have a good evening.